So welcome back everyone, part 2 of topic 10. So when we left off we were talking about some of the definitions and explanations in the explanatory material for this section 3 capital L capital A of the Commonwealth Crimes Act. And then I promised we were going to come back to Justice White's ruling on this section in the Lupino case in 2019. So, Justice White focused in part on the privilege against self-incrimination, and he quoted Justice Dean from a 1995 High Court case of Reed and Howard. And Justice Dean in that case had said, the privilege against self-incrimination is deeply ingrained in the common law. It reflects a cardinal principle which lies at the heart of the administration of the criminal law in this country. It can be and has increasingly been overridden or modified by the legislature. It can be waived by the person entitled to claim it. Otherwise, it is unqualified. In particular, it should not be modified by judicially devised exceptions or qualifications. Unless it appears that the assertion of potential incrimination is unsustainable, a claim to the benefit of the privilege cannot, in the absence of a statutory warrant, properly be disregarded or overridden by the courts. So, what His Honour Justice Dean was saying, that it's a fundamental common law right. It's to not be compelled to incriminate yourself, and only a specific statutory override should be respected by the courts. Any other suggestion that it should be watered down judicially should be resisted. So you can maybe see where Justice White is going to go with this. But anyway, he's setting up the scene by quoting Justice Dean in Reed and Howard. So, we need to take this privilege seriously, Justice White is saying. It's an important aspect of our criminal justice system. And the thing is, Section 3LA does abrogate the privilege against self-incrimination and can compel, with threat of 5 years imprisonment or 300 penalty units, compliance with an order to effectively incriminate yourself and hand over all your information. So, the issue then moves to definitions. So Justice White asked, was the Samsung phone a computer or a data storage device for the purposes of Section 3LA? And in a related question, how much assistance and access should or could be required under Section 3LA? So he says, people have their whole life stored on their phone, and that seemed overly broad to Justice White, and he says it may extend to confidential or sensitive material unrelated to the commission of any crime. And I'm sure many of us can relate to a situation where you might store financial passwords or other sensitive passwords, health information, all sorts of private information, personal content on our phones, which wouldn't necessarily be relevant to, well, in Daniel Lupino's case, an allegation of a specific crime. So it's too broad, isn't it? Can you see the problem? That this provision forces the handing over of swathes of information based on the allegation unproven at this point, that's why they want information, the allegation of a specific crime. You're going to tip out all of your data. So, the following discussions you can follow along when you're having a look at the judgment from paragraph 36. And I urge you to read the case, it's interesting, where Justice White even puts a heading, Approach to the Construction of 3LA. So Justice White starts his approach to try and interpret Section 3LA by saying we should follow what the full court of the Federal Court said in Hart and the AFP in 2002. And in that case, they said that in accordance with Project Blue Sky, so when we know this case, don't we, the one that talks about not only the meaning that Parliament has taken to have intended the wording of the legislation to have, but then the other most important tenet of Project Blue Sky is you have to construe the relevant provision so that it's consistent with the language and purpose of all of the provisions across the whole statute. And if you remember Project Blue Sky, High Court talks about the legislation or even a scheme of legislation achieving a harmonious goal and achieving harmony between the provisions of the individual statute and scheme as best as the court can. And they said that in Hart also that the purpose of search and seizure provisions is to provide for the gathering of information to determine whether offences have been committed and then to facilitate proof of that. Recognition of that purpose may yield a construction of the legislative words which is not necessarily narrowly defined. Remaining ambiguity or doubt, whether of meaning or application, will be resolved in favour of the rights and freedoms of the subject. All right, so on the one hand, you've got a proposed, the purpose of the search and seizure provisions, such as 3LA. The whole point of it is to provide for the gathering of information and to facilitate proof of a commission of an offence. So with that purpose in mind, the idea would be to interpret the wording of the statute so it can achieve that purpose of best gathering evidence. However, if consistently with this purpose there's still some room for ambiguity or doubt, then any further doubt should be resolved in favour of the subject or defendant because of this common law principle of legality. So the search and seizure provisions of the Crimes Act are not punitive. They're not to be treated as a penal provision. It's more appropriate to see them as subject to the general principles that govern statutory interference with established common law rights and freedoms. So this may seem a little bit incongruous, mightn't it? In light of Section 3LA, a search and seizure provision, having these orders from a magistrate, the breach of which can result in 5 minutes imprisonment, it's not penal provision. So you do have to consider the context a bit. And you could say, couldn't you, arguably that Section 3LA could be seen as a penal provision. In which case, as we know, the rule there is any ambiguity should be resolved for the benefit of the accused. Okay, so let's back to the Lupino case. Both sides agreed the approach in Hart was largely the correct way to proceed. So remember, in a case like this, the applicant's legal team, Lupino's team, is contesting the order by Magistrate Gregory Fisher. Hence, Lupino and Fisher is the name of the case. And the way our adversarial system works is not just that they present doubt about a provision and the judge then works it all out. It's incumbent on them to present arguments, both sides presenting arguments as to the proper way to interpret the provision under dispute. And then the judge accepts or rejects the arguments from either side. And that's the idea of our adversarial system, that no one's better placed to argue their case than the parties to the dispute. So both sides agreed that Hart was largely the way to go in the current case, but the plaintiff, Lupino, noted that since 2002, a number of subsequent decisions of the High Court had then indicated and highlighted the importance of the principle of legality. to an extent that may not have been fully understood in 2002. All right, so these cases Lupino's legal team raises have increasingly relied on the principle of legality when it comes to legislation, which might implicitly override people's common law rights, such as fair trial, rights of which, it's just like a set of rights, if you like, of which the privilege against self-incrimination is a member of that set. And then on the other hand, counsel for the commissioner, so the AFP commissioner was joined to the defence in this case with the magistrate as well. So you've now got the magistrate and the commissioner of the Australian Federal Police on the one side and arguing a certain interpretation of the provision, and then Lupino and his legal team on the other side saying no, this is too broad. So the commissioner's lawyer emphasised the principle of legality is a rule of construction and that it can't rewrite legislation. So we've got Lupino's team saying the principle of legality has been emphasised or promoted in a certain way recently by the High Court over the last couple of decades beyond Hart case, so more so. And the opposing side was reminding Justice White that it's just a rule of construction. It can't rewrite the plain meaning of the Crimes Act. And as we know, due to parliamentary sovereignty, if there's a clear abrogation of rights in the legislation, well, then these presumptions have to give way. Separation of powers. All right, so the plaintiff Lupino's contended that the order in section 3LA of the order to be, for it to be valid, it has to identify a particular computer or a data storage device. Now section 3LA does not authorise, so the submission ran, in respect of any computer or any data storage device. So sort of a vague and general order is not authorised by that section, so there's no power for it. Now, Justice White has a fairly lengthy discussion of this in his judgment, so you have to have a look at paragraph 156 to 167, and he said that it's significant because the AFP seized the two phones and a laptop, and that the magistrate's order lacked sufficient or requisite clarity. And the other thing that he found was that the term computer was not defined in the Crimes Act. So the party then had to argue about whether mobile phones are under the definition of a computer. So Justice White's turned, in the absence of a definition, to the dictionary definition using his dictionary of choice, which is the Macquarie. And in there it said, an apparatus for performing mathematical computations electronically according to a series of stored instructions called a program. So fairly general definition that can encompass a range of different kinds of computers. However, remember what the second reading speeches were from 2001 and 2009 from the two Attorneys General, said about computers and networks and so on, and going into premises and networks of computers with external servers. Justice White says there's nothing in either of those memoranda or the speech in 2001 to suggest that the terms computer and data storage device were intended to encompass mobile phones. You know, which is interesting, isn't it? Because the definition is capable of encompassing a range of storage media, including DVDs, CDs, USBs. It may well encompass other forms of storage media. However, the term data storage device does not seem apt to encompass a mobile phone. There's nothing in the legislative history, the explanatory memoranda, the second reading speech, that suggests that the term was intended to encompass a mobile phone. Such items have been so ubiquitous for so long that it's natural to expect, isn't it, that had Parliament intended that Section 3LA should extend to a mobile phone, it would have been obvious for it to have said so. So Justice White is taking the approach that Parliament ought to be held to a certain standard of clarity, and in 2001, okay, perhaps not so many of the AFP's investigations involved mobile phones. A lot of people had them in 2001, but maybe not have been ubiquitous. A lot of people still using pagers and phone boxes and landlines. However, by 2009, they certainly were. They were everywhere. And it's fairly obvious in Justice White for Parliament to include the definition of a computer if there had been the intention of Parliament and the search and seizure orders and the mandating of people to open them up. He felt it should have been then spelt out and called a mobile phone. So while a mobile phone may have the capacity, says Justice White, to perform mathematical computations electronically, according to a series of stored instructions called the program, it doesn't really seem apt to call such an item a computer. Now, I can hear computer scientists saying that's ridiculous. Mobile phones are just a small and miniaturized computer, a supercomputer in your pocket, I've heard it called. Essentially, they're a single board computer. If you think of something like a Raspberry Pi, it's just a single circuit board with what's called a system on a chip or an SoC, and a mobile phone is just similar to that in just a miniaturized form. So all the elements, CPU, storage, input, output, that you find in a desktop computer or even a laptop computer are just as they exist in a mobile phone as well. They're just miniaturized. So from a technological point of view, this could be a bit of a clanger from Justice White. However, continuing on in his reasoning, mobile phones, he said, are primarily devices for communicating. Now, again, you might have some doubt here. Text is a big part of the business of phone use. Voice calls is reducing. So what he's saying is it's primarily devices for communication, although now it's commonplace for them to have another number of other functions. It does sound a bit dated, but you know, essentially it's a phone, isn't it? From A to B to communicate. Yes, we scroll and we search and we do other activities. We might play games, we might post on social media, but it's still a phone. So he's saying, they're primarily communicating. So Justice White goes on, however, there are numerous goods and devices which may be said to contain computers, such as motor vehicles, TV sets, refrigerators, DVD players, and the like, but none of those in common parlance are called a computer. And he's probably on stronger ground here, isn't he, that you wouldn't call your washing machine that you could turn on remotely a computer, would you? Your car has had computers in for years, but you wouldn't really say the car's a computer. Maybe a Tesla, maybe you'd say that's a computer, but even that you might still say, no, it's a vehicle. This is computer controlled. So I think, yeah, what do you think? So computer scientists and engineers might take the view that a mobile phone is just a computer running off a modified form of the Linux operating system, but the rest of us would probably picture a laptop or a desktop when someone says, "Oh, I've lost my computer," and not a phone. Anyway, and Justice White goes on, the very ubiquity of mobile phones suggests that if Parliament had intended that they should be encompassed by the term computer, it would have been obvious to say so. Also pertinently, he says at 186, pertinent that Parliament has not chosen to use the term electronic equipment in 3LA, even though it uses that terminology in 3L and 3LAA. the term electronic equipment seems to have a wider meaning than does the term computer or data storage device. And then that impression is confirmed by section 23ZA, 23ZD, and 23ZF, which in relation to child abuse material refers separately to a computer, a data storage device, and another piece of electronic equipment. This is critical, right? We're getting to context, aren't we? If you're trying to understand what the words computer and data storage device means, well, if there's neighboring provisions that seem to use it differentially, so says computer, data storage device, and another piece of electronic equipment, well, that provides context, doesn't it, to your comprehension or application of the word computer and data storage device. So he's digging into context. He's looking at related provisions to see if they use wording which might then shed light on the wording of 3LA. And he says that these other provisions say, and the other electronic devices so logically, that the omission of that from section 3LA implies that other electronic devices were not meant to be covered. Otherwise, why would you carve it out in those other provisions? So he's saying there's other categories, and the phone falls into those. All right. So have a think about Justice White's conclusions, his ruminations, I suppose, on the meaning of the word computer. Do you think they were reasonable? Do you think it was just a drafting or a legislative oversight or one of these legislative gaps that we talked about in topic 8 for Parliament not to refer to phones or tablets or at least other electronic devices for 3LA if it intended that police should be able to seize and order access to such devices? All right, I'll pause there for part 2 and we'll come back in part 3 where we're going to have a look at the full Court of Appeal in this case.